Let's talk about self-defense laws in New York. A lot of people get this wrong. A lot of people think that if you defend yourself in New York, you can't bring forward a self-defense claim, and that's simply not true. In fact, I've had clients who've been arrested for assault, and the police officers tell them, oh, in New York, you can't defend yourself. And I'm not sure where the police are getting that from, but it's not true. So in New York, under Penal Law 35.15, which is the section of the law that outlines self-defense laws in New York, as you'll see if you look at it, you are allowed to use force if you reasonably believe it's necessary to defend yourself against the use of force against you, or the imminent threat of force against you. So if someone is coming towards you and they're starting to punch you, or they're getting, they're putting their arm back like they're getting ready to punch you, you can use force to defend yourself, and you have a self-defense claim. You should not be found guilty of assault against that person. That said, there are a few exceptions that apply. So for instance, the self-defense claim does not apply if you provoked the assault. Additionally, if you were the initial aggressor, meaning that you threw the first punch, or if the assault against you or your assault against that person was the product of like a duel. So in other words, both parties agreed to fight each other. In that situation, neither party can claim self-defense. Now, I think what a lot of people get hung up on in New York is this whole concept of stand your ground versus duty to retreat. And it's important to know that the duty to retreat or stand your ground analysis, that only applies to the use of deadly physical force. It doesn't apply to the application of just regular force, so for instance, a fist. So the duty to retreat does exist in New York, but it's only if you are using deadly physical force against someone. So for instance, like a knife or a gun. However, the duty to retreat is not absolute. You must actually have belief that you can actually safely retreat. So in other words, if you're on the street, someone comes up to you with a knife and you're cornered, and let's say you have a knife and you reasonably believe the use of the knife is necessary to defend yourself, in that situation, you don't have to retreat because you can't even retreat. Additionally, if someone invades your home, you can use deadly physical force against them if they're using deadly physical force against you or threatening such use. In that situation, you don't have to retreat. You don't have to run out of your home. You can use deadly physical force to defend yourself. Additionally, there are certain offenses, and you can see this in Penal Law 35.15 subsection 2, where if the perpetrator is using or is committing certain offenses, for instance, rape or robbery, and they're using deadly physical force against you while in the commission of those offenses, you can use deadly physical force against them, and you don't have to retreat. You can actively defend yourself in those situations. So in sum, you can defend yourself in New York if you believe that the use of force is reasonably necessary to defend yourself. And the use of deadly physical force is a little more tricky. There are situations where you do need to retreat, but in a lot of standard situations where you'd be wanting to use you need to use deadly physical force in the first place, for instance, a home invasion, or if someone's trying to rob you or rape you, you can use deadly physical force if you reasonably believe it's necessary to defend yourself. If you have a case in New York and you think you have a self-defense claim, give me a call. We can talk about your case and we can develop a defense strategy.